Welcome to Empowered. I'm Elizabeth Namofsky. Having a will is extremely important, and it seems to be a minor thought for many. Wills are a way for the deceased to tell everyone what their wishes are after they die. On previous episodes of Empowered, we've discussed the topic of what to do and look out for when you're named an executor of an estate. Today, we're going to talk about hot topics in estate planning, what to look out for, and what's important and why it's important. I'm joined by Rachel Goldman Robinson, a partner at Torkin Manes LLP. Rachel will walk us through the estate planning process, what's involved to create a good will. Rachel, welcome to Empowered.
Thank you, Liz. It's so nice to see you.
It's great to see you as well. Let's begin, though. When should someone think about having a will prepared?
So when we talk about wills, there's a lot of issues that come up. And I guess the first thing is, what is a will, right? A will is a legal document that allows somebody to dispose of their assets after they pass away. And it can be written by hand, which is called the holograph will, but we focus on wills that are typed up, that are relatively complicated in terms of provisions. But it doesn't have to be. I think the main thing to think about is certainly if a person has children, it's a really important time to think about having a will in place, because a will allows you to make a provision for appointment of guardianship or someone who has decision-making responsibility for your children. And without that, it can cause a lot of issues with people. If both parents are gone, people making applications to the court and fighting. So certainly when people have children, but even if they don't have children and they have assets that are of value, either sentimental value or actual financial value, then it's a document that allows them to dispose of those assets after they pass away in an orderly fashion and appoint the proper people to make the decisions and to help administer the estate. And, if you don't have a will, there's a lot of issues that come into play. So certainly as soon as somebody has an asset or as soon as somebody has children, it's a really good time to think about what's going to happen to the children and to the assets after they pass away.
So I want to dig into probate. A lot of people are terrified of it. It's like, oh, I don't want to go through probate. So could you please explain what is probate?
So we get asked that question all the time. So probate it's actually a slang term for a certificate of appointment of estate trustee, which is issued by the court. And it's a process where the executors submit the will to court for the court to certify that this is the valid document of the deceased. So if you think of it in a simple term, let's say somebody has a bank account at a bank and there's $50,000 in the bank, and they pass away, and I show up at the bank and I have a will from the deceased and I have a death certificate, and I say to the bank, can I please have access to the account? Well, if the bank gives me access today to that account and tomorrow you show up with a later dated will and a death certificate, and you say, no, actually, I'm the executor, this will is the valid will, but the bank had already given me the access to the account, then the bank is liable because they improperly gave the funds to somebody else. So large financial institutions, for example, won't give access to those accounts without something that they can rely on, so that if you came the next day, they can say, well, I relied on this document from the court that told me that this is the valid will. So the banks will ask for what we call a probated will. And that's a will that was submitted to the court, and it was certified by the court because the executors who submitted the will swore affidavits, they gave notice to the beneficiaries. And so it's a process that the will basically gets vetted and a document gets issued that these third-party institutions can rely upon and then release the funds. Now, the issue with probate is that in making that application, you have to pay in Ontario approximately 1.5% probate fees on the value of the assets that are under probate. So if a deceased had one will, even if certain assets don't need this probatable document, you have to include the value of the entire estate in that probate application, and the entire estate is subject to the 1.5% probate fee. We do lots of probate planning strategies, and one of those is having dual wills where we carve out certain assets so that we don't have to pay that 1.5% probate fee. But if there's only one will, then all assets of the estate would be subject to that. Now, it's really important to know that...
Just hold that thought for a moment. Hold that important thought, because unfortunately, I really have to go to commercial break. So please don't go away. We'll be right back with more.